on.
Thank you very much. Good morning, everyone. Today is Monday, November 9th, 2020, and this is a regularly scheduled meeting of the Real Estate Appraisers Commission being held via WebEx and also on the telephone. We will begin with a call to order, and I will believe Mr. Garrison as the acting chairman. Would you please give us a call to order?
So moved. We will start with a roll call.
Thank you, sir. Let me get my... Okay. Mr. Garrison.
Here.
Mr. Bennett. Mr. Bennett, are you able to hear us? I can see Mr. Bennett on, but we are unable to hear him at the moment. We will...
How about now?
There you are.
Okay, sorry about that.
No problem. Thank you. Let's see. Ms. Johnson. All right, Ms. Johnson is not present. Mr. Atwood.
Here.
Mr. Mansfield.
Here.
Ms. Alexander.
Here.
Okay. Now I'll ask our staff attorney, Anna Matlock, to read the statement of necessity, please.
Okay. This is an electronically scheduled meeting of the Tennessee Real Estate Appraisers Commission. Notice of this meeting was posted to the Commission website on Monday, November 2nd, 2020. As there is not a physical quorum present, the statement of necessity will be read into the record and filed with the Tennessee Secretary of State as required by statute. Pursuant to Tennessee Code annotated section 8-44-108B2, which states if a physical quorum is not present at the location of a meeting of a governing body, then in order for a quorum of members to participate by electronic or other means of communication, the governing body must make a determination that a necessity exists. That determination must include a recitation of the facts and circumstances on which it was based. Further, Tennessee Code annotated section 8-44-108A3 defines necessity as matters to be considered by the governing body at that meeting require timely action by the body, that physical presence by a quorum of the members is not practical within the period of time requiring action, and that participation by a quorum of the members by electronic or other means of communication is necessary. As stated, this is a previously scheduled meeting of the Tennessee Real Estate Appraiser Commission that is now being held via Cisco WebEx. The purpose of this meeting with members attending by Cisco WebEx is to conduct regular business of the Commission, including but not limited to experience interview recommendations, the Executive Director's report, and complaints. Furthermore, it is necessary for this meeting to be held electronically in accordance with Executive Order Number 16, issued by Governor Bill Lee on March 20th, 2020, further extended by Executive Order Number 65, issued on October 28th, 2020. To ensure government continues to function open and transparently during the COVID-19 emergency while taking appropriate measures to protect the health and safety of citizens and government officials. All voting will be conducted by roll call.
Thank you, Anna. The next item we have is to adopt the agenda. Would entertain a motion to adopt the agenda.
So moved.
We hear a second. Okay, thank you very much. And just for good measure, we'll go ahead and call the roll for that. Mr. Garrison?
Yes.
Mr. Bennett?
Yes.
Johnson's absent. Mr. Atwood?
Yes.
Mr. Mansfield? Did we lose Mr. Mansfield? Oh.
Yes.
Thank you, sir. And Ms. Alexander?
Yes.
Thank you very much. So since the last meeting, we're now moved down to the election of officers. Since the last meeting or scheduled meeting of this group, there have been a couple of changes to the composition of the board. We had, due to term limits, we have lost our chairman as well as our education member. Both of those seats have nominees in process, and we are awaiting their oaths of office before we include them in official proceedings. However, I believe, I think one of them has joined us today, but I believe Dr. Jane, who is from West Tennessee and at Memphis, University of Memphis, is on the call today, and he will, as soon as we get his oath of office, we will be sending him all of the things that Dr. McCara had handled for us before. And we also have our lady, Carrie Haston from East Tennessee, who will be joining the board in the seat that was vacated by Mr. Thomas. So with that in mind, I would like to, we're going to have to officially replace Mr. Thomas as the chairman of the board. So at this time, I believe we would take nominations for the chairman's seat. Are there any nominations for chairman?
I'll nominate Rex Garrison.
I'll second that.
Okay, I was taking notes. Who nominated? And I saw Michelle, you seconded, but who was the nominator?
I did, Brett Mansfield.
Okay, thank you very much. And as these motions go forward, would you all please identify yourself just for the record, because this is virtual and not visual. So just as you make a motion or second a motion, would you please state your name for the record? All right, so we have a motion and a second for Rex Garrison for chairman. Are there any other nominees? Okay, hearing none, I will call the roll. Mr. Garrison,
Yes.
Mr. Bennett,
Yes.
Mr. Atwood,
Yes.
Mr. Mansfield,
Yes.
Ms. Alexander.
Yes.
Okay, thank you very much. That motion is carried. Mr. Chairman, this is Rex Garrison. Let's see now. We will need a vice chairman at this point in time. As we now have a chairman, I will turn the process over to you, Rex.
All right. Do we have any motions for vice chair?
Nominate Jim Atwood.
Oh. I'll second that.
Just for clarification, would you please, who nominated?
Jason Bennett.
Okay, and second was,
Brett Mansfield.
okay, thank you very much.
Are there any other nominations? Hearing none, let's vote on the nomination by roll call.
Yes, sir. Mr. Garrison,
Yes.
Mr. Bennett,
Yes.
Mr. Atwood.
I'll abstain.
Okay, Mr. Mansfield. Would you say that again, please?
Yes.
Thank you, sir. And Ms. Alexander? I believe that was a yes.
Yes.
Okay, great. Congratulations, Mr. Atwood. Okay, let's now move on to the next item on our agenda is to review and approve the July 2020 minutes. Those were included in your material packet for this meeting. I hope everyone has had a chance to look over them. Are there any changes, or would you all like to move to approve?
Move
I
that we
move to
approve.
approve.
Okay, we have a move to approve from Ms. Alexander.
Second from Jason Bennett.
Thank you, Mr. Bennett. Second from Mr. Bennett. We'll call the roll now. Mr. Garrison,
Yes.
Mr. Bennett,
Yes.
Mr. Atwood,
Yes.
Mr. Mansfield,
Yes.
Ms. Alexander.
Yes.
Thank you very much. The minutes have been approved. Okay, the next item on our agenda is a report of experience interviews, recommendations. Let's see. I don't believe we have any at this point, and I apologize. Yes, we don't currently have any. So,
As far as experience, I think on page 16 of the PDF.
Yes, I have 3.
Yes, I have 2.
Yeah, and I have 3.
I have one.
oh, forgive me. I'm sorry. I looked at those and I saw those as the legal. My apologies. That's why I was confused there. So, my apologies.
We could probably handle those all together. All of them are recommended to approve.
The second one on mine, I've got it cleared up as well, and so that's going to be a yes. So
Okay.
Mr. Garrison is correct.
So is there a motion to accept all of these at once?
So moved.
Second that, Brett Mansfield.
Okay, we have a motion and a second. Any discussion? We will vote via roll call.
All right. Thank you, sir. Mr. Garrison,
Yes.
Mr. Bennett,
Yes.
Mr. Atwood,
Yes.
Mr. Mansfield,
Yes.
Ms. Alexander.
Yes.
Thank you very much. And we're starting to pick up a little bit of an echo. I'd like to remind everybody, if you're not speaking, to please mute yourself. Thank you. Now, this one I know for sure, the education report, I know for sure we don't have any. However, I would like to keep a bit of uniformity to the agenda and have you all used to seeing the same items in the same places. So for the education report, because of Mr. Makara's term limits and the timing in which we were able to get Dr. Jane, we were unable to make any education assessments regarding this. However, during the next scheduled board meeting, we should have plenty to report on under education. So at that point, I would like to move to the legal report and turn it over to Shalina Brown, please.
Yes, good morning, Commission members. This is Shalina Brown. I will be presenting the legal report. Today's date is November 9th, and this is the November 2020 legal report. The first item is 2020044871. The complainant is a Tennessee resident and the respondent is a licensed residential real estate appraiser. The complainant had multiple of dealing with the respondent and appraisals. In one instance, the complainant represented the buyer of a home which had previously been of for sale for owner property. Property went under contract on June 26, 2019 for $229,000 with a VA loan and $6,500 was requested in closing costs. The tax records appraised value showed the value at $211,670,000 in 2019. The Zillow estimate was for $236,150. According to Zillow, the home sold for $259,000 on October 1st, 2019. There was a $23,000 discrepancy, and the homeowner refused to negotiate the price downward. The buyer lost $4,000 making changes to moving and temporary housing arrangements because the buyer had to find another home. The complainant also listed a home for $270,000 with a VA loan and asked for $6,000 in closing costs, and the seller had already purchased a home and made extensive upgrades and updates. All upgrades were submitted to the respondent and again used another appraisal firm and submitted 4 more comparables. The respondent declined all 4 of the comps submitted by the complainant and stated they fell outside the 6-month window by a couple of weeks. Another one of the comps closed outside of the 6-month period by a couple of weeks, and another closed 1 year before the March 2019. It appears the respondent had a preconceived value and was determined to make the price fit. The assigned value on the property was $30,000 below the contract price. The other contract was for $270,000, and the seller was contributing $5,000 toward closing costs. Within 3 weeks, this contract fell apart due to the buyer not being able to obtain financing. Due to the COVID-19 pandemic, the price of the home was reduced to $260,000 and went under contract for $258,000 on April 8, 2020. The home closed on May 8, 2020. The appraisal was for $258,000, which is at the very least $18,000 more than the respondent's appraisal. There were 2 real estate agents that stated the house was worth about $265,000, and there were offers submitted in the $270,000 range. The ultimate sale was much lower because of the aggravation, frustration, and subpar appraisal by the respondent. The complainant believes there may have been a personal vendetta by the respondent or possibly just sheer incompetence. The complainant questions the respondent's professional ethics concerning VA appraisals. The respondent provided a response and stated the respondent does not know the complainant and has never met the complainant. There has never been a personal or professional relationship with the complainant. The complainant cited 2 separate appraisals in the complaint, and the respondent was engaged by the VA to complete the assignments, and the respondent completed those assignments by selecting the most reasonably similar recent and proximate market data with no bias towards the contract price in accordance with USPAP and the Georgia standards of appraisal for the assignment. The respondent recognizes that the contract price is part of the market data that represents a meeting of the minds between the buyer and the seller. The 2 assignments in question did not have market support for the contract price. The respondent appraised the first property in Georgia twice, once in February 2017 and a second time in June 2019. The property is located in a very rural part of Georgia, and the properties is located in a very rural part of Georgia, and the quantity and quality of data is limited. The 3 sales selected were from the subject property's competitive market area. The market extracted condition adjustments were applied to 2 of the 3 sales to reflect the subject's appreciating market. The 3 comparables included in the report, 2 of the 3 were not supportive of the contract price. For reconciliation, the respondent used the weighted ranking method, and accordingly, the probable market value was $206,000. This was a VA assignment, and since the probable market value was less than the contract price, the Tidewater Initiative was invoked. The agent supplied 3 properties, 2 sales which were already included in the assignment, and a third that had not closed as of the effective date of the assignment, as the appraiser noted in Tidewater notes in the appraisal, despite closing after the effective date of the assignment. This sale would still not have been supportive of the contract price after market-based adjustments were applied. The second appraisal was for a property appraised in March 2020, and this was located in a highly confirming and established neighborhood in a suburban town. The quantity and quality of the data was very strong for this assignment, with ample data in the subject's immediate neighborhood. 5 comparable sales were selected from the subject's immediate neighborhood, while a 6th highly similar extensive renovated sale was also selected from a superior, higher value neighborhood. 6 comparable sales included in this appraisal. 0 of the adjusted sales prices were supportive of the contract price. The reviewer did not make any findings with the appraisal, and there were no violations of use path, and the appraisal was properly conducted, and there were no errors. My recommendation is to close this matter.
I have a question. You noted in here several times this property's in Georgia.
Yes.
Why are we looking at it?
The complaint, because this appraiser is licensed here, I believe that the complaint was filed in Tennessee as well. But there were several appraisals, from my understanding.
But all in Georgia.
Yeah.
Do we have jurisdiction in Georgia?
No, but we have jurisdiction over the appraiser.
But only if the property's in Tennessee and he acted as an appraiser in Tennessee.
Well, if there is an issue with an appraiser in another jurisdiction and they're licensed in Tennessee, then we also do have jurisdiction.
Well, the reviewer didn't find anything. The properties are located in Georgia. I make the motion we close.
Second, Michelle.
Okay, we have a motion to close and a second to close. Further discussion? Hearing none, let's vote via roll call.
Thank you, sir. Mr. Garrison,
Yes.
Mr. Bennett,
Yes.
Mr. Atwood,
Yes.
Mr. Mansfield,
Yes.
Ms. Alexander. Thank you very much.
Before we start the second one, let's try to speed this up. I think the cases 1 through 7 were all recommended to close. I think in the past, if we've had several to close, we can take a motion to close them all at once, or if somebody wants to talk about one, we can pull it out. But it was 1 through 7. We've handled 1, so it would be 2 through 7. Is there any of 2 through 7 that anyone wants to discuss?
I would like for us to discuss 4 and 5.
Okay. So that would leave 2, 3, 6, and 7.
This is Brad Mansfield. I'll make a motion that we close those 4.
This is Michelle. Second.
Okay, we have a motion and a second. Further discussion? Hearing none, let's vote via roll call.
Okay, just to be clear, this is a motion to vote en bloc to accept the recommendations for legal number 2, 3, 6, and 7. Mr. Garrison,
Yes.
Mr. Bennett,
Yes.
Mr. Atwood,
Yes.
Mr. Mansfield,
Yes.
Ms. Alexander.
Yes.
Thank you very much.
Okay, so let's move to case number 4. And if you want, you can just sort of, I guess, read it into record. I think we've all had time to read these, so I don't think you need to read everything. If you want to summarize, you can, but go ahead and read it into record, and then we can discuss.
Sure. Number 4 is 2020059-201. This is a complainant is a Tennessee resident, and the respondent is a licensed certified residential real estate appraiser. The complainant alleges the respondent was hired as a VA appraiser for the property. The allegation is that the respondent has a history of exceedingly low appraisals and did not come to the property for very long and was only there for 15 minutes. And the list price of the property was $215,000. The offer price was $217,000. The respondent's appraisal was for $183,000. There was a $34,000 difference in list price. The reviewer concluded that the respondent does not have a history of conducting low appraisals. The respondent was not at the subject property because the respondent had previously conducted an appraisal of the same property in 2014 and had sketched the property out. All rooms and the attics were re-inspected and photographed. The time spent at the property was longer than that was actually stated by the complainant, and my recommendation is to close this matter.
Hearing the case for a motion or discussion.
Yes. I'm confused on the reviewer's conclusion. I don't see where the reviewer did anything other than looks like interview the respondent. Did the reviewer actually review the report, and did the reviewer have any response to the actual report? I don't see where that's stated here.
I'm sorry. I would have to check. I don't know if this was actually sent to a reviewer. It might be stated as being sent to a reviewer conclusion when that actually was the respondent's response here.
Yeah, that's what I thought. My personal feeling on this one is that we can't really make any decision on this one until we have this reviewed and a reviewer respond back to us.
Okay, so I will defer this to the next commission meeting.
Well, I mean, that was my opinion. I don't know if we need to vote on that or not. My recommendation is that my motion would be that we send this to a reviewer and that it be provided to us at the next meeting.
We have a motion. Is there a second?
Second that, Brett Mansfield.
We have a motion and a second to defer this case to the next meeting. Further discussion? Hearing none, let's vote via roll call.
Mr. Garrison,
Yes.
Mr. Bennett,
Yes.
Mr. Atwood,
Yes.
Mr. Mansfield,
Yes.
Ms. Alexander.
Yes.
Thank you very much.
Okay, just to give you an update, I did check on this, and this was sent to a reviewer in early September, and we have not received a response. We have followed up, but in any event, I will find out the reviewer's findings and report back to you at the next commission meeting. I believe the next one is number 5. That's 2020064-171. This complaint was administratively opened by the Tennessee Real Estate Appraiser Commission. The respondent is a licensed residential real estate appraiser. The Fannie Mae Loan Quality Center conducted a review of the respondent's appraisal in April 2019 and concluded there were substantial errors that led to a non-credible result. The review found the following issues: inappropriate comparable sales, selection due to location, use of dissimilar comparable sales due to site characteristics, and use of physically dissimilar comparable sales, gross living area. The respondent provided a response and said the subject property was a log home and in average good quality, well-maintained, marketable condition, and had an oversized 2-car attached garage and front cover-wrapped porch. There was a low number of recent comparable log homes. The comparables that were used were log homes and were the most comparable and located in the same county with similar marketable attributes. The GLA data was reasonable based on the market data. My recommendation is to close.
So I have the same issue with this one. It looks like we had a Fannie Mae review, but we did not have one of our own state reviewers to review this. Is that correct?
Yes, this was not sent out for review, and the response of the respondent that it was a log home was the reason, and the explanation and provided by the respondent also.
Yes, I have the same problem with this one. I think that we're going to need to have one of our state reviewers look at this and make a recommendation.
We have a motion. Is there a second?
Second it.
Okay, we have a motion and a second to defer this case. Further discussion?
I have a question on it. It says it was open administratively. How were you notified of the Fannie Mae loan quality review?
I believe, I'm not sure quite exactly how the process works, but I believe that Fannie Mae reports it to our office. Michael, if you can correct me if I'm wrong.
No, that is correct. Fannie Mae sends those to us.
Okay, so you're getting all, and the reason I ask this is I see at least one of these a week where they come back to an appraiser because they say something's wrong with their, appraisal based on their loan quality review. And the reality is all they're trying to do is make the lender indemnify the loan because there's something about it they don't like. So they're notifying you of every single time they come back to an appraiser or a lender saying that there's errors in an appraisal report.
I don't know if they're notifying us every single time, but they definitely notify us, and at which time I believe legal these notifications are routed to legal at that time, at which point they open the complaints administratively.
I will say this, about 85% of all these that I deal with are completely ridiculous and have no basis whatsoever, and we win when we fight them over it. That's just my 2 cents.
Yeah, I'd like to put some 2 cents in this as well. Why doesn't Fannie Mae file a complaint? Why are they not the complainant?
If you would like, Commissioner Atwood, if you would like that process to proceed in the future, we can recommend that Fannie Mae be the person that filed the complaint. It's just that this time we got notification of it, and I believe I recommended that we go ahead and open a complaint. We didn't really have a procedure set in place. So if you want to change that, we can do that.
Well, yes, I don't know if that requires a motion, but I think that if they're going to send this in and then put the responsibility on us to whether a complaint ought to be filed or not, I don't think that's appropriate. If they have a complaint, they ought to file it. They ought to be registered as the complainant. We should not be putting the pressure on our legal department to determine whether these things rise to the level of a administrative complaint or not. I mean, I agree with Mr. Bennett that, and we could be, if we had to review all of these complaints that Fannie Mae finds some little nitpicky thing wrong with it, you know, we'd be here all day long. I just don't think this is appropriate. That's my thoughts on it. Somebody else can speak.
I would agree. I think Fannie Mae needs to be the complainant.
Okay, we can make sure that process is followed forward.
I would just like to add, this is Shalina Brown. Based on my limited experience so far with these Fannie Mae reviews that are submitted to our office, many of them are computer generated as well and flagged, and that's how the review process begins. So often the computer is identifying based on some sort of algorithm of some issues related to a appraisal.
Yeah, just to chime in on that, it's based on collateral underwriter, and the collateral underwriter score changes based on the amount of data that they have and the algorithm risk that they want in a specific area. So we have scores come in, 1 week it'll be a 5, which is the highest risk they consider. And then, 2 weeks later, we'll have to go back for some minor correction, re-upload the same report, and it's dropped to a 3.8. Well, nothing changed in the report other than a typo. So I don't, that's the reporting score, the risk score that they have is completely inconsistent. And it can be manipulated based on data that's put in and or their risk appetite.
Do I have a motion? I forgot whether I made one or not. I think I did. Is there a motion, Mr. Chair?
Yeah, I believe you did.
Okay, I'd like to withdraw my motion.
Okay.
And I'd like to make a new motion, if I can, to dismiss this.
Second.
Okay. We have a new motion and a second. Any further discussion? All those in favor, well, I'm sorry. We'll vote via roll call.
All right, I will call the roll now. Mr. Garrison,
Yes.
Mr. Bennett,
Yes.
Mr. Atwood,
Yes.
Mr. Mansfield, Mr. Mansfield, we weren't able to hear you.
Sorry, my internet's lagging. Yes.
There we go. We got you that time. And Ms. Alexander. Please repeat that.
Yes.
Okay, got it. Thank you very much. And I believe that means we can move on to number 8.
Just a moment, please.
Oh, sorry.
We need to deal with this going forward. Do we need to a motion, is the motion required that the next time one of these comes in, that, that it be required that Fannie Mae actually be the complainant? Do we need a motion on some of that, or how, or do we just need to give an opinion of a direction to our legal department?
I don't think a motion is required. But if you would like to make a motion, just to be sure, we can do that, but we can also just move forward with that going forward.
I would just as soon move forward, but I'm the only one talking on that. Maybe some of the other commissioners would like to comment on their opinion regarding that.
If it pleases the commission, if I may, just for a second, we had a similar issue come up with the Architects and Engineers Board where complaints were being filtered through seated board members. And the board members didn't want to be the ones to open the complaint because they would then have to be the one to, kind of give a review of the complaint. So what we started to do there was kick it back to the person who initially approached the board member and ask them to then go to the website and lodge the complaint. If these reports or which we've been opening administratively are generated through a computer system, we could try and figure out some way to go back to Fannie Mae and ask them to go in and lodge these complaints through the website. But this won't be an overnight fix if we're going to have to go through automation. So we can move forward with the understanding that we will take a look at it from our end here in getting in touch with Fannie Mae and then be able to report back to you on what we're able to do.
Yes, sir, that works for me.
Yeah, that would be good.
Okay, we'll take that on and we'll get back to you and let you know how we're able to work things out with Fannie Mae.
Very good. Thank you, Michael.
Are you taking are you taking public comments for this or not? I have one comment I put in the chat box as well.
Mr. Chairman, would you like to accept public comment on this, or would you like me to read the chat box?
Yes, why don't you go ahead and read that?
Okay. The chat box says many boards are going in the direction of searching for issues with licensees from multiple sources and flagging them instead of ignoring potential issues.
Any comments, commissioners? Okay, hearing none. Let's just move forward. We'll keep that in mind. We're probably going to see more of this moving forward. And we just need to be on the alert. Both legal and the commissioners looking for these. Why don't we move on to number 8?
Okay, number 8 is 2019055151. This matter was previously presented to the commission. The complainant is a Tennessee homeowner and the respondent is a certified residential real estate appraiser. The complainant alleged that the respondent's appraisal had several inaccuracies, including size of the site, condition of the property, the room count, the bedroom count, the gross living area, and a failure to include the size of the screened-in porch. The complainant alleges that the lender made the respondent aware of the discrepancies, and another report was issued with 2 of the 3 same comparables used, and this was produced within a 24-hour period, and there was a change in the square footage reported by the respondent. The commission had previously held that there should be, hang on one second. The commission voted to issue a consent order with a $1,000 civil penalty and to require 30 hours of sales comparison continuing education to be completed within 180 days of execution of the consent order. This was sent out to a reviewer to review the additional information that was submitted by the respondent. The reviewer reviewed all the additional information and stated that the site value presented in the cost approach section had not been supported by the report or the work file, but the respondent had admitted in his response that the search criteria parameters utilized in this report should have been revised. The reviewer determined the explanations for the remaining adjustments appear to be reasonable. The additional comments and calculations were provided in the additional documents and notes submitted by the respondent. These additional notes were done during the appraisal but had not been submitted or provided to the commission. The 3 sales that were used in the sales comparison approach and the review of the data accessed from the MAR and the MLS and the respondent's work file were utilized to verify the sales information used in the appraisal report. The physical information noted in the report about the sales and the listings appears to have been properly reported. The size adjustment was considered, but there was no explanation on the other amenities affecting the price per square foot. There were no comments provided to address how the age difference would affect the conclusions presented. The additional comments and calculations were provided in the recent information furnished, and all this information indicates the respondent has an understanding of the difference between the subject and the comparables used, but there was no adequate analysis on how the noted adjustments were derived, and this can result in the clients or intended users being unable to understand the rationale for the opinions and the conclusions provided in the sales approach to value. The respondent did develop the income approach, and the exclusion of the income approach was adequately explained. The reviewer submitted the market conditions addendum in the appraisal report. By admission, this information was not corrected in the data submitted in the addendum. The information has been adequately reported. The reviewer determined the respondent has an understanding of the differences between the subject and the comparables. These should have been submitted with the original work file, and the record-keeping rule requires the work file should have been in existence prior to the issuance of any report or other communication of assignment results. My new recommendation is to require 8 hours of report writing and 7 hours of sales comparison approach continuing education, in addition to the minimum requirements for continuing education within 180 days of signing of the consent order.
We have a recommendation on this. Do I hear a motion or any discussion?
A question, just for clarification, council's recommendation is these classes in addition to the continuing education requirements, correct? So they wouldn't go towards those requirements.
Correct.
The new information appears to me to have been created after the appraisal report was turned into the client and the initial work file was compiled and all of this. And then we took action in a previous board meeting where we had a consent order against the appraiser, and this information has come in addition to. All of this information should have been available at the beginning, and all of these things should have already been explained in the appraisal report. You know, you don't wait till you get a complaint before you start explaining everything. You should explain it before you turn the appraisal report into the client. None of this was done. So there are many USPAP, in my opinion, USPAP violations regarding this appraisal. And to me, the 8 hours report writing and 7 hour sales comparison is not sufficient. We already have a motion that was approved. The original motion was to issue a consent order of $1,000 civil penalty and require 30 hours of sales comparison. I suppose that decision is still in effect unless we change it. Is that correct?
Yes, that's correct. But let me be clear that upon review, the information was available. It had just not been provided, and it may not have been in an organized fashion to, for someone to adequately review. But the information was all there. It was not provided with the original. That is correct.
Well, the reviewer still indicates multiple deficiencies in the report, even after additional explanation, if I'm reading that correctly.
Yes, there are still, yes.
Therefore, I think that the respondent does need additional educational work. I would be in favor of eliminating the $1,000 civil penalty, but I think that it needs more than 8 hours of report writing. And can I revise the motion? Can I make a motion or revise it?
Yes, sir.
My motion is that we require 14 hours of report writing, 14 hours of sales comparison.
We have a motion. Is there a second?
I'll second that.
Okay, we have a motion and a second. Further discussion. Hearing none, let's vote via roll call.
And just to be clear, that was Mr. Atwood who made the motion and seconded by Ms. Alexander, correct?
Yes.
Correct.
Okay. Very good. Thank you. Mr. Garrison,
Yes.
Mr. Bennett,
Yes.
Mr. Atwood,
Yes.
Mr. Mansfield,
Yes.
Ms. Alexander.
Yes.
Okay, thank you very much.
The next complaint is a represent. It's 2018062301. The complainant alleged unlicensed activity on a mass nationwide appraisal where hundreds of millions of dollars of cell phone tower property was being appraised. The review shows approximately a dozen cell phone tower properties in the state of Tennessee were evaluated. The respondent was not licensed in Tennessee, but had signed a report which had stated that he was a certified appraisal on a mass multi-state valuation, and he received assistance from several named individuals. The appraisal report that was provided to the expert reviewer had over 1,000 pages of supporting documentation, and the appraisal report was actually a valuation of certain assets of a certain company. And this was provided by a firm, an accounting firm, to provide a retrospective valuation service of its recapitalization transaction in 2016. And the valuation concluded the fair value or fair value of one unit in the company. The expert reviewer found that this alleged appraisal report constituted a fair value report with no association to USPAP, and said that the report was a disservice to USPAP as well as an appraisal report of real property. The original recommendation was to dismiss. The commission had voted to authorize a consent order with a $1,000 civil penalty and open a complaint against the temporary licensee identified in the complaint. There was further information provided by the attorney for the respondent, and most recently, the attorney for the respondent has provided extensive information stating that this was an anonymous complaint that was submitted to 4 other jurisdictions in the United States, and it was filed by a disgruntled former employee who was on a team of a large accounting project. The former employee also tried to take some of the business of the firm when departing, and the former employee was unsuccessful, and that's when the submission of these complaints to the various other states began. In 9 of the other 12 states, the matter was closed and not acted upon or dismissed with no further enforcement action. In 1 state, the matter was closed with a letter of caution. The remaining state, the respondent is contesting the enforcement action, and that includes, as well as in Tennessee. This respondent's firm was retained by a communication company to perform a valuation of assets, which were cell phone towers, following a transaction that required allocation of the refinancing purchase price after the transaction had been closed. This was not an appraisal required by a party prior to a sale or any transaction. This was a valuation by the client's real property with FASPA requirements, including accounting standards codification number 805. The engagement was not providing an appraisal of real property. The task was simply to allocate an already established purchase price that was already agreed to prior to the transaction being closed before the respondent's firm engagement. The respondent does not hold a Tennessee appraiser license and did not function as a real estate property appraiser in the engagement. The work performed by the respondent did not fall under the definitions of the appraisal assignment as defined in the Tennessee appraisal statute. Appraisal means the act or process of developing an opinion of value of identified real estate. That opinion of value may be numerically expressed either as a specific amount or as a range of numbers or as a relationship to a previous value opinion. The appraisal assignment means an engagement for which an appraiser is employed or retained to act or would be perceived by third parties of the public as acting as a disinterested third party in rendering an unbiased analysis, opinion, or conclusion relating to the nature, quality, value, or utility of specified interests in or aspects of identified real estate. This was not an engagement to determine appraised value, but merely a value. The entire project was an internal accounting function and not a real estate appraisal function. The respondent was in the team leading the large project and performed services for the internal accounting function for the corporation. Additionally, in Tennessee, cell phone towers are designated as a public utility under the statute. The firm made sure there was a licensed Tennessee appraiser on the team, and the team member has obtained the necessary licensing from the commission. And at that time, they had a temporary license, but obtained a permanent appraiser license. My recommendation is to close this matter.
We have a recommendation. Any motions or discussion?
I have a question. Is a cell phone tower, real property or a
Based on my review of this, in some states it is considered real property. However, in Tennessee, it's designated as public utility property.
Do any of my fellow board members have any experience with this?
Typically, and I've been in the situation of valuing various cell phone towers as far as the property. And that's where this one sort of concerns me. They've tried to go around throughout a lot of definitions, but I guess my concern with this, they come out and say that it's not real property, but yet they felt like they needed to get a temporary license to do it. And then the report that was submitted didn't fare well from the reviewer's recommendation. So, and then they come back and said that they have somebody that has a permanent license. So obviously they feel that they need someone licensed to do so. And it goes back to the report that was submitted. I can't remember what we did with the temporary license.
I thought the temporary license, it either wasn't, the dates didn't line up, or it was for only one property, not all the properties. Does that ring a bell?
Yeah, they came back and the terminology on it fell to a project, not necessarily property specific. Now, I was always under the belief that it was per property, not necessarily per project. But that definition was given to us, I think, back in the spring.
Another question. Does appraising a cell phone tower involve appraising land? Or is it just the structure itself?
Typically, they either buy the land in which it's set on, have an easement to that section of land, or they will lease a section of land and put a tower.
So did this appraisal, we don't know, do we, include land value?
Correct.
It did.
Well, we don't know. But,
okay, we don't know.
Yeah, the reviewer, and this goes back, this thing's been going on for about a year. We go all the way back to the original in what the reviewer's recommendation was, that the report did not meet USPAP. And I understand that they're doing things on the accounting side, but I've run into situations where accountants are sort of bleeding over into valuing real property, and they don't necessarily have the law behind them in doing that. I've run into that on some estates.
I think, I mean, when you look, there's brokers who are doing the same things, but don't have an appraisal license. For me, I mean, they had an appraiser who was licensed in the state perform a valuation that didn't comply with USPAP. I don't see anything really new that they brought, in this most recent response.
I agree.
I'd like to say that, there's this gray area here, and because of the definitions under the statute, it would be very difficult to proceed. And that's the main reason why I recommend that this matter be closed, because this did not function necessarily as an appraisal. It was a valuation, and it was not, meant to serve as an appraisal either.
I don't think the definitions really apply. I think the definitions are thrown out there in a way to sort of gray this issue over. What I have found in situations like this, they will go out, hire an appraiser to value that component. Then they take that value and incorporate that into the business valuation side. And so I think there is an element of valuation of each of those cell towers, and most likely each one is either on lease land or land that was purchased. And that's part of their assets. And that's where it becomes gray as far as the information that we're given. I mean, we could throw out definitions all day long, but, it's one of those, if it walks like a duck and quacks like a duck, then there was probably a valuation done here. And that's the concerning side. And that they've even gone out and they've got a temporary license and they've hired an appraiser or had an appraiser become permanently licensed in Tennessee, tells me that they know what they did was wrong.
I agree with that 100%.
So Rex, you're saying that one way or another, you think that land was included in the valuation, either by ownership or by a lease. At least the valuation had to include real property as regarding the land. We could debate all day whether a cell phone tower is personal property or a trade fixture, but it's attached to the land. So you're saying there definitely was real property involved, at least from the land value. Is that what you're saying?
That's what I'm saying. Unless they excluded that, but if they excluded that, why did they feel it necessary to have an appraiser as a part of it?
And just because an item is called a value and not an appraisal value doesn't mean it's not an appraisal.
Correct, because there are certain exclusions in the state of Tennessee, and this would not be one that would be excluded.
Yeah, they're specifically stating that it was internal, and the exclusion applies to banks.
Correct.
Commission members, if you'd like me to find out the details concerning the property that was valued, then I can do that and report back to you on this case.
I think it goes back to going to the original report that was submitted and looking to see what interest was valued.
Just for clarification, I was under the impression there was more than one report. Is that correct? Or more than one property?
Yeah,
That's what I remembered.
Yeah, it's about
I think
12.
it's 12. Yeah, 12 properties. And we don't know if they were dismissed in the other areas because they actually had a licensed appraiser in those other areas, and it didn't go beyond unlicensed activity because they had somebody else who was licensed in those states.
Is this something we could take back to the reviewer and have them relook at this again, or to a different reviewer?
Yes, I can have this submitted to the reviewer.
I think that would be good. One is what was identified that was valued and what interest was valued. Both of those are USPAP requirements.
To know too if the temporary licensee actually signed the report or not.
So do we need a motion to send this back then?
Yes, please.
Okay.
So I'll go ahead.
I'll entertain a motion.
I'll make the motion.
I'll second it. Brett Mansfield.
Okay, we have a motion and a second. Further discussion? Let's vote via roll call.
Okay, we have a motion from Ms. Alexander, second by Mr. Bennett. And let's see, Mr. Garrison.
Yes.
Mr. Bennett.
Yes.
Mr. Atwood.
Yes.
Mr. Mansfield.
Yes.
Ms. Alexander.
Yes.
Thank you very much.
That concludes the legal report.
Thank you.
Thank you.
Let's move on to the legal report or the rule updates. Hannah?
Okay. So you should have a copy of the red line that is going to be changing 1, 2, 3, 4, 5 different provisions of the rules based upon the request by the commission to allow synchronous courses to be taken completely online for qualifying education and for continuing education. So the amendments that we're making, the first one is going to be to Rule 1255-01-.051B2, and it's going to remove the certain subsections that the commission had previously delineated for certain courses to be taken online. So it's going to allow all of the courses listed under qualifying education for appraisal education to be taken via distance education. So we're making that same change also to section 1255-01-.071B2 and 1255-01-0.081B2 as well. So we're just removing the courses that we had specifically included in those sections of the rules. And then section 1255-01-.127H, that's going to amend the registered trainee section to remove the phrase no more than 1/2 of the required education credits can be taken via distance education. And you'll see that there's a new subsection that's going to be added in chapter 1255-02, specifically -.04. We're adding a new subsection 9. And this is just information that I took from the AQB criteria that pertains specifically to distance education. So I'll go ahead and read that into the record just so we have it. In addition to distance education requirements, distance education courses intended for use as qualifying education must provide a written closed book final examination proctored by an official as approved by the college or university or by the sponsoring organization. The term written refers to an examination that might be written on paper or administered electronically on a computer workstation or other device. Oral exams are not acceptable. The testing must be in compliance with AQB examination requirements for qualifying education. So we did have some language in our rules already with these requirements, but I just wanted to make sure it was absolutely clear that the qualifying education requirements in our rules match the AQB criteria. Does anyone have any questions for me?
I have a question on the definition of distance learning, or is it going to include, or does that definition include asynchronous and synchronous in?
So hold on one second. I'll pull the definition of distance education up for you so you can see. I looked at that and it didn't need to be changed. Hold on one second. Where is Okay, so the definition for distance education means the educational process in which instruction does not take place in a traditional classroom setting, but rather through other media or non-conventional methods in which the teacher and student are separated by distance and sometimes by time, and the course provides interaction. So that would cover the difference between synchronous and asynchronous. So for asynchronous courses, you're going to be separated by time, and synchronous courses we're going to be separated by distance. So there's no need to make an amendment to distance education definition.
Very good. Thank you. Any other questions?
Am I correct that the AQB has not authorized synchronous education for QE?
No.
I do believe at the Aero conference, we did have a conversation that I believe until the end of 2021, the AQB is going to allow qualified education courses to be taught synchronously. Is that correct, Chairman Garrison?
Yes, that letter that I sent you this morning that I guess it was from the AQB to Mr. Jim Park at the ASC, that they have included qualifying education as far as to be allowed virtually until the end of 2021, similar to the continuing education.
So did you say that came out in writing or just?
Yes.
So there is something written on that. Okay. I just haven't seen it.
It was fairly recent.
We can send it out to you. That was one of the topics that they talked about at the Aero conference. So because of the pandemic, they're going to allow continuing education courses and qualifying education courses to continue via synchronous method through the end of 2021. So therefore, because of that, and we have a writing for that, I think we would just need to have a motion by the commission to adopt those requirements.
We're calling at the same time here, so it's kind of crazy. I'm just interested in, the letter from the ASC.
Hey, Laura, can you please mute Mr. Stockman?
Of Arizona is going to improve, QE and CE.
Okay, thank you. I think we would need a motion to adopt those requirements and those changes that have been from the AQB to the ASC, and then we can go ahead and proceed with these rules via normal rulemaking process, rulemaking hearing process, as we do have that latitude in time until the end of next year.
Hey, Anna.
So,
I'm sorry. Quick question. So those,
Yes.
that would be effective immediately if we adopted those changes.
Yes.
And then what we're proposing here is no longer under the emergency. This is the traditional change. So we're probably looking later next year.
Correct. My goal is, so if we get these passed today, then they'll be routed, and hopefully we can have a rulemaking hearing at the next meeting, and then it should be able to proceed and be enacted prior to the end of 2021. So my goal is for us to have this in permanent writing at the end by the time that the expiration goes from the AQB. So I think proceeding normally through the rulemaking hearing process is the appropriate route.
And I think that we had already voted on adopting whatever changes the AQB.
Right. I don't know if I know that we voted on continuing education, but I don't think that we voted on qualifying education, as this was just a new directive. But please correct me if I'm wrong.
I remember, but I don't, it's just my memory that we did say any other changes that the AQB may come up with that we would accept them as well. I think that's what we did.
Okay.
I think you're right.
Okay, no problem.
So let me be clear. I just want to be 100% clear. I understand. If we accept the AQB's recommendation for synchronous education for QE, they can start offering those courses today or tomorrow.
Correct.
Thank you.
That is only for synchronous, not for asynchronous, correct?
Correct. Yes. So it would be synchronous course taught via WebEx, Zoom, one of those type of platforms.
I think.
Well, if you just want to have it in the record, I make the motion that we accept the AQB recommendation that QE can be performed in synchronous education, that we accept that recommendation.
I'll second that. And this is Brett.
We have a motion and a second. Further discussion. Hearing none, let's vote on the acceptance of the AQB recommendation to the ASC via roll call.
Thank you, sir. Mr. Garrison,
Yes.
Mr. Bennett,
Yes.
Mr. Atwood,
Yes.
Mr. Mansfield,
Yes.
Ms. Alexander.
Yes.
Thank you very much.
Okay,
So now we
and
need to vote in the red line.
yes,
Is there a motion concerning the red line report?
Motion to accept.
We have a motion. Is there a second?
Second, Jim Atwood.
Okay, we have a motion and a second to accept the red line version. Further discussion? Hearing none, let's vote via roll call. Did I
Michael,
lose?
you're muted.
Okay.
Okay, now I'm not muted. It's got to happen to somebody, right? Mr. Garrison,
Yes.
Mr. Bennett,
Yes.
Mr. Atwood,
Yes.
Mr. Mansfield,
Yes.
Ms. Alexander.
Yes.
Okay, thank you very much.
So to be clear, right now we've got the 79 hours for a trainee that can be done online, and now other QE can be done through synchronous, virtual, correct?
correct.
Very good.
So I'll go ahead and get these rules moved, and hopefully we can get the rulemaking hearing at the next meeting.
Very good. Any other legal information?
Yes, Commission members, this is Shalina Brown. Just to tidy things up, I'd like to just state the complaint numbers for those blocks of cases that were closed by motion of the Commission. That was number 2, 3, 6, and 7. Number 2 is complaint number 2020047831. Number 3 is 2020051601. Number 6 is 2020035851. Number 7 is 2020036471. Thank you.
Very good. Thank you. So we're ready to move on to the director's report.
All right, thank you, and thank you to the legal team for those updates and reports. The first item that I have for my report is you will notice a redacted email exchange and some images of legal documents that are up for review now. Caleb Darnell, who has been working with the individual regarding this question, is on the call right now and will be available for questions should you have any for Caleb. But as my understanding is, this is a preemptive review before an official application process. Before an official application process has even begun, the person who has submitted this would like to get an understanding from the commission on whether or not the criminal conviction or the conviction in general would prohibit this individual from obtaining a license within the industry in the state of Tennessee. And I'll leave that out for discussion from the commission members.
Okay, thank you. Any discussion?
Well, is there a law that prohibits this individual from obtaining a appraisal license? Is there a written law?
So if you are all remember the Fresh Start Act, was passed in 2018, and it was added as an amendment to some of the rules already in place. And specifically, we have rules that if you have a criminal conviction on your record within the previous 5 years, then that individual will need to appear before the commission to see if they can be licensed. And then it was amended to saying that the provisions of the Fresh Start Act shall be complied with. And so since this particular individual's conviction is considered to be a class B felony. That is why we brought it before the commission to make a determination whether or not the individual can be licensed or not.
You said within 5 years. So if this was over 5 years, there would be no law prohibiting it. Did I make sense? You're muted, I think.
Anna has rather vocally active dogs, and I believe at this point, one of her dogs has sounded off.
Sorry, I apologize. So the commission, and the rule says the commission, and if you wanted to look for reference, it's under 1255-09-.092. It says the commission may deny an application for registration, license, or certification if the background information for the applicant includes A is a conviction of any felony, and then B states convictions of any criminal offense, including dishonesty, breach of trust, or those type of actions. So I think I previously stated that it's within 5 years, but I don't actually see that. So it just says conviction of any felony. So this individual's would fall into A. So it's not a requirement. It says the commission may deny. So it is not a shall. So it is up to your discretion what you would like to do.
And I have a question for you. What were the reasons specifically? You said breach of trust and what else?
So B is it's similar to good moral character, but it says B is convictions of any criminal offense involving dishonesty, breach of trust, or money laundering against the individual or organizations controlled by the individual, or agreements to enter into a pretrial diversion or similar program in connection with the prosecution for such offenses. So it wouldn't fall into that category. It would fall into category A, which is the conviction of any felony. And so the Fresh Start Act is something that is analogous to this. So conviction of any felony is very broad. So one of the things that the Fresh Start Act did was to allow individuals with certain criminal convictions to be allowed to get their license. And if it was to be denied, we have to go through a whole process about why it's being denied. So it really kind of rules out Class D and E felonies, which are some of the lower level drug felonies, but Class A, B, and C felonies are considered felonies that have a rebuttable presumption that they do apply to the particular profession that the individual is seeking to apply to. But that's not an end all be all. It's just a presumption. So typically, since this person qualifies as a conviction that falls under Section 2A and one of the felonies that has a rebuttable presumption under the Fresh Start Act, that is why we brought it before the commission for you to make that determination. There is nothing stating that you have to deny an application. It's just the possibility.
I'm just going to go ahead and say it. I don't know if anybody else is thinking it. My concern is this gentleman would potentially be going into people's homes with potentially young children there. I don't know if he's gotten any therapy or whatever is necessary for what he went through. And, I'm sorry for that, but I don't, this isn't something I can vote for.
Okay, I will also like to let you know, I don't know if this is up to you or not, but the individual that we're discussing, Mr. Riggins is on the line. So if you would like to ask him any questions, that's definitely available at this time.
Got just one more question for you there, Anna. So they are just asking what our thought would be on this when the
Right.
time
So
comes.
yes. So Mr. Riggins has not applied for application yet. He wanted to get the commission's point decision on based on this criminal conviction whether or not he could proceed to an application for licensure.
But this is just our opinion. So whatever we say, I mean, it might take him 5 years. That might be an entirely new commission here with a different opinion than what we're not approving his application.
Right. So instead, it's just like a preliminary decision. So if you said yes today, then Mr. Riggins would proceed with the application process to become an appraiser. And if you said no, then most likely, I don't want to speak to that. He probably would not proceed with the application process. Typically, when we have individuals that have criminal convictions, they'll come before the commission prior to placing or to making an application, just so they, without expending money, time, those kinds of things.
I've got one particular question for Mr. Riggins, but if it would be possible, if he could come on and just make a statement, a comment that he would like to make to the commission. But my specific question is, does he have already in place a potential supervisor?
Yes, this is Mr. Riggins. I have a supervisor at the moment. I'm actually on probation, which I'm actually on minimum supervisory probation, which I only have to report every 3 months. Here lately, it's been virtual. I mean, if anybody has any other questions, I can give you all a breakdown of my background, what all I've been through, and I've actually been in treatment with the Veterans Affairs. But if anybody has any questions, I'm available to any questions.
Are you presently in treatment as far as for the PTSD?
Yes, sir. I'm in treatment right now. I'm in an outpatient clinic here in Columbia, Tennessee. I've been seeking treatment since 2018, I believe, since the incident. And right now it's very minimal. Like my caseworker, she's about ready to actually sign off on me. And she's been working with my probation officer as well. This is my first offense. I've never been in trouble in my life. I was in the military, and I do have a disability of PTSD. But this is my first offense. I've never been in trouble in my life. Something happened back in 2018 that shouldn't have happened. I'm just trying to get my life together. I'm about to get married and have 2 children myself, so.
Any other questions?
Mr. Riggins, you stated in here that you have joint custody of your children. Is that all 3 of them?
I do have joint custody 50-50. I have a stepchild. Well, not yet, technically, because I'm not married, but my two biological children, I do have 50-50 custody. I get them every other week, which I actually get them today until next Sunday. I was supposed to get them yesterday, but plans changed. But anyways, I do get them every other week. They are here with me. My fiance, she doesn't live with me. I take care of my children. I'm working for a delivery service at the moment, and I'm also a full-time student enrolled at Southern New Hampshire University. I have about a year left in my bachelor degree program. So that's pretty much it. I just take care of my kids, work, and then work on school.
And to clarify
Riggins.
this, I'm sorry, go ahead.
I was just going to ask, Mr. Riggins, do you have a potential appraiser supervisor lined up?
Not at the moment, ma'am. I have not even got that far. I'm sorry.
And to clarify in here, this was one case, one instance, one time.
Yes, sir. It happened one time, just the one incident. I was actually charged back in 2015, but in 2018 is when I finally went to court 3 years later, and that's when I was convicted. My attorney kept trying to push it back, just to prove that I'm responsible enough parent. I mean, I didn't have any restrictions against my kids. I was allowed to see my kids. I was still able to come home. My wife, ex-wife at the time, she was here, and it was pretty much a normal day. The only thing was I couldn't sleep here at night, so I had to go to my aunt's house every night and sleep. But other than that, it was pretty much a normal 3 years after I was charged, and then I was finally charged. I served 3 months in jail. I was sentenced to 180 days, but I only did 3 months due to me being a trustee and good time, so I only served half my sentence. And now I'm just on probation, reporting every 3 months.
Okay, so you only had one count of against you, and then when does your probation expire?
It expires in 2030. It's actually a 12-year probation. I'm actually trying to, halfway into my probation term, I'm going to try to take it back to court and try to get it knocked out or knocked out completely. Due to me being on minimum supervisory and good behavior, and it's my first time offense, so I'm going to try to get knocked down.
Mr. Riggins, we have a really tough decision to make here. We want to give people benefit of the doubt that they're improving their life. We're not here to judge people's lives, and so we really would love to give you the benefit of the doubt. I'm sure everybody on the commission would love to do that. I know I do. However, we are charged to protect the public. And those two things weigh against each other. I wonder if it would be possible for you to provide some additional information that might help us, and that is a letter from your ex-wife, a letter from your counselor, a letter from your probation officer, and anyone else that you think could give us a recommendation that you are prepared to move forward with your life in a positive way. Are any of those things possible?
Yes, sir. They're very much possible.
Anna, is that possible for us to delay this and ask for those things?
Sure, if you would like additional information, we can just hold until the next meeting to make a decision.
I would like that information. I'll let the other commissioners speak to that.
I think that's a good idea, Jim. I would feel more comfortable if I had some information, like you said, from the counselor, from the ex-wife, from the doctor whose treatment it sounded like you were getting ready to be finished with. All of that would give us some additional information for us to consider. It's a pretty weighty issue.
Do we need a motion on that?
Yes, why don't we?
I make a motion that we delay this decision until we can receive additional information, specifically from the ex-wife, from the counselor or doctor that Mr. Riggins is working with, and from his probation officer.
Second.
Okay, we have a motion and a second. Further discussion? Hearing none, let's vote via roll call.
All right, Mr. Garrison,
Yes.
Mr. Bennett, Mr. Atwood,
Yes.
Mr. Mansfield,
Yes.
Ms. Alexander.
Yes.
Thank you very much.
Thank you, Mr. Riggins. Let's move on to the financial statements.
And Rex, if I could real quick, Mr. Riggins, you will, I believe you have been working with Caleb Darnell here in our department. You'll continue to, as you gather these materials, just keep forward them on to Caleb or whoever you may have been working with in our division, and we'll make sure to get this stuff in front of the board commission members.
Yes, sir. Will do. Thank y'all.
Thank you. Okay. Financial statements. I believe you all have seen these before, but this being my first time to run through them with you, just would like to point out this is the financial report for this fiscal year starting in July and through September. We do not have or are not in receipt of October just yet, but that will be included in the next meeting. I'd like to direct your attention to the far right column. At the bottom of the first section, you'll see 134,265. That is our gross from this year so far. And if you follow that column down to the bottom of the next section, you'll see our expenditures of 79,482. I can't tell if that's an 8 or a 9, but I'm looking at a printout, so it's a little bit smaller. And then our net so far for this year, $54,773. Are there any questions regarding this year's gross and or expenditures and net? Okay, not hearing any. Then all I have for you regarding the ASC grant program is I know that this has been spoken of in the past. I believe you all, or at least Roxana might have made mention of it in the July meeting. Internally, we've looked at the ASC grant program, and given the way 2020 is, we currently don't have a need to be the recipient of a grant. What we're doing is our as you can see from the financial statements, our reserves is well above the expected yearly cost and expenditures to run this program. And given that most everything has gone virtual and there's not a need for in-person gatherings at this point, we've tried looking at a number of different things currently, and we're still working on it. We're still reviewing, but we've tried to look at everything from figuring out how we might offer a free class to all of our licensees and have multiple different instructors involved throughout that process. But what it really came down to was we couldn't figure out the justification for needing to apply for a grant at this point in time with so much money in reserves. So myself, Caleb, and Will and Morgan on the team here are going to continue to monitor that process. And our hope is that as things hopefully get back to something what we're used to calling normal situation, where in-class or in-person classes are the mainstay, we hope that we might be able to find other ways to potentially use this money. But just wanted to give you all an update on that because I know that it had been a topic of conversation in the past. Any questions regarding anything that we have talked about on the director's report? Okay, hearing none, we can move on to new business. And sorry?
Yeah, new business. I have one thing, and it's a question for Anna. And it was part of the email I shot you earlier about the PARIA that has been approved for experience grading or for experience. And that goes into effect January 1. What do we need to do as a commission to be ready for that, and what changes need to be made?
So I just got the document this morning. What I'll do is I'll review the document prior to, I know it goes into effect prior to our next meeting. But I will discuss with Michael what changes, if any, need to be made, and then we can communicate with you guys via email what changes, if any, will be made.
Very good. We meet so early in January that this really won't be an issue.
Right.
But I wanted to get it on your all's radar because I'm sure there's going to be several want to take advantage of this, and we'll need to figure out how we're going to handle it going forward.
I do have a question on that, Rex. If you could, and I'm sure everybody is pretty aware, but explain a little bit more in detail what exactly I've read it, and I feel like I understand what it's saying, but is this saying that you'll not need to have any supervisor at all potentially?
I'm not 100% sure how much experience they will receive, far as how much experience credit. That was one thing that has been debated. This has been in the works for a couple of years, but that was one thing, and I don't know what they ended up deciding. I'd have to go back and read it again. I don't think they came back with 100%. I could be wrong.
Rex, if I could jump in here just quickly to clarify for those who have not seen this document, and there was an acronym used to begin this conversation. I just want to clarify and say that the PARIA stands for Practical Applications of Real Estate Appraisal. That's all. Thank you.
Okay, thank you. I'm scrolling down.
Anna, could you make that document that you're going to review available to us? I have not seen it.
Absolutely. I'll have it sent today.
Thank you.
In scanning it, Mr. Bennett, it looks like they will allow. As a result, the AQB proposes Perea be eligible for up to 100% of the required experience for licensed residential and certified residential classifications, respectively.
That's what I thought, but I just found that hard to believe. But I guess
Yeah,
that's correct.
well, that was debated. I've been at a couple Aero meetings where it's been discussed, and I think that's where the hangup was. How much credit were they going to allow? And I guess my thoughts with COVID, I think they've sort of pushed it a little bit farther.
And I have one other question on education, just so I'm totally clear. I have multiple people who work for me specifically that are in the process of getting their continuing education or qualifying education. You can do 100% asynchronous or synchronous at this point, qualifying and continuing.
So it's 100% of continuing education can be taken synchronously,
Okay.
and qualifying education can be taken synchronously. That's what's been allowed by the AQB and ASC. It does not apply to asynchronous courses.
Okay, so so we need to update, and the reason I ask is the state website still says half is required in a classroom.
Right. So we're working to change the rule. So that would be updated. But we can look to adding a note or something on the website to let them know in this interim time this has been allowed. And that also just wanted to clarify that the courses must be approved previously in order to proceed in a synchronous method.
Yeah, the in-classroom courses have to be approved to do synchronous.
Correct. So it can't be a course that we haven't seen yet, if that makes sense. It has to be a previously Tennessee approved course.
Right.
Okay, so and then they have to request the approval to go synchronous before you can be given credit for that. Is there a list anywhere that shows what is approved and what isn't approved?
Correct. So we have a listing currently of courses, but a list will be posted to our website for individuals to look and see.
I actually had an item that's very similar to that and wanted to bring that up at this time. I had an appraiser contact me earlier this year when this change was kind of in process, and this individual was their licensed appraiser and were working on renewing their license, and had asked me about the change, and there was some miscommunication, and I may have told him the wrong thing, but what they did is they took I guess an asynchronous course in place of where they needed a synchronous course. They went ahead after learning that, took the course and applied for their license, and got the renewal. And I told them that I would ask the commission and you and see how we could do this, but if there's any way that course that they took could be applied to their next cycle for continuing education. Given that it's just there's a lot of moving parts, and I probably didn't tell them the right thing, and should have pushed them in the right direction. But anyway, I don't know, how do we go about that? Is that something that we can look at or do?
So if you'll just forward us the information, and we can take a look at it and get back to them. I don't want to blanketly state something without knowing all the facts, but we can definitely provide some kind of clarifying information to licensees with the new directive from the ASC and AQB regarding synchronous courses. So if you'll just have them reach out to our licensing staff, we can take a look at that particular issue.
would also like to point out that we do have a section on the main page of our Appraisers Commission website, and it is, I believe it's the second one down. It's entitled Virtual Courses. The AQB has 4 guidelines as to what synchronous course must have, and we have included all of this material on our main landing page.
We allow for half of our CE to be taken online, so now it's just the other half may be taken synchronous, correct?
Correct.
Any other discussion? Hearing none, I will entertain a motion.
To dismiss?
We're at the end of the meeting. There we go. Yeah.
Motion to dismiss.
Second.
All right. We have a motion and a second to dismiss. All those in favor? I guess we do it via roll call, or can we just dismiss?
No, sir. I don't believe there's a roll call vote needed for to entertain a motion for adjournment.
Very good. Very good. Thank you all for all your work.
Thank you.
Yep,
Thank
I
you.
echo that, and we will have those documents from this new business section out to the commission members here very shortly. Thank you all for joining us. Have a great day.
Thank you.